In the first panel, we heard a little bit about the importance from the tribunal's perspective of not asking questions as a tribunal member in the same way that you would ask them if you were advocating. Agree? Disagree?
Yeah, oh yes, yeah, oh yeah, absolutely. And Hilary made an excellent point. It's just amazing. You'll have a witness, and would you state your name for the record? This is from opposing counsel. Would you state your name for the record? Yes. What is your name? Can't get anything. And then when the tribunal is asking the questions, they open up. And no, the question, when I'm an arbitrator asking a question, no, I don't ask leading, pointing questions. I'm not trying to make a point. I'm trying to understand the truth. So very different, Mark, very different approach. And typically the process, there may be some isolated questions from tribunal as you go, but generally we hold our questions till counsel have had their say, and then follow up.
If we accept the proposition that witnesses will not be forthcoming to advocates' questions, and if the object is to convince the tribunal, does that mean then that your question should go first as the arbitrator? To give counsel something more to work with, perhaps?
Well, I mean, there may be different views on this. My practice and experience has been that unless it's just a matter to clarify a question of fact or some particular detail about what they just said about a document or what was it, yes or no, generally I think the practice is, and I think it's right, let the lawyers have their go at it, and then the tribunal. And then following the tribunal's questions, anything else from counsel prompted by the question. But I had not thought about it, Mark. There may be some point to that, but I've actually never seen it. The questions from the tribunal have always come after lawyers have had their chance.
Hilary?
I was going to say, in a lengthy cross-examination, sometimes it's easier for everybody when counsel is moving to a different topic for the tribunal to ask its questions then. To clarify that they are moving to a different topic and then give counsel a further opportunity rather than save a whole ragbag of different questions till the end. I mean, it very much depends, but that's something I sometimes do.
Jim?
And you have to make a judgment about counsel before you, too. Normally, the presumption is they know what they're doing and they're good at it, and you stand back out of their way. But with the example that Hilary gives of a topic comes to an end, and you feel that there's something there that they didn't ask that further question, and you have to kind of make a judgment. Are these counsel who probably did that for a reason and they're going to come back to it, leave it alone, or are you never going to get an answer unless you ask it?
But you can always, I mean, I always ask the counsel, have you finished with that topic before I ask the question? So that rather preempts that point, I think.
And you think they've finished.
Well.
How about in the room? Would you prefer to have the arbitration tribunal talk to your witnesses first? Would you prefer to do it yourself first, followed by the tribunal? No volunteers, huh? We have to go back to the sex, I see. I think we're losing everybody before lunch. Is there any topic, because I have a long list, but is there any topic in the few minutes that we have remaining that's on the audience's mind that we can help with? Because that's the reason we're all here, is to try to assist and facilitate. Yes?
Thank you. As we know, civil law lawyers are not used at all to cross-examination. Just to give you an Italian perspective, first, according to the code of ethics that we have, we are not allowed to talk to witnesses or to try to make arrangements with them. And this could also be even a criminal offense. So I have two questions. According to the experience of the speakers in the panel, when you start an arbitration procedure where there are counsels which are civil law lawyers or parties which come from countries, civil law countries, how do you manage this point? I mean, you give for granted that it will be possible to have cross-examination, or you deal with the subject and maybe you make an agreement because, for instance, from our point of view, if there is an agreement that cross-examination will be possible and that lawyers can talk to witnesses and so on, in that case, of course, you can do that. So it seems to me that it is very important at the beginning of the arbitration procedure to make it clear this point. So I was wondering, which is your experience? First question. Second question, from a practical point of view, since as it has already been mentioned, we have different culture, different background. I think that if you have a tribunal with 3 members, for instance, and one is an American lawyer, and the other 2 are, I don't know, a French one and an Italian one, I mean, there might be controversies even in the way you proceed with the cross-examination. So I was wondering, do you deal before starting the procedure also with this subject also among the members of a tribunal? These are the 2 questions. Thank you.
Excellent questions. Who wants to deal with the first one? Robert?
So I think the short answer to the question is yes. It is important to deal with these issues up front. One simple way is often just to say that the tribunal will follow the IBA rules, at least as a guideline. And that includes not just the point that it's permissible to prepare a witness, but it includes lots of other issues that would otherwise take a long time at a procedural hearing to deal with and to debate. But this issue of different cultures is also very important from a common law lawyer's standpoint. And there's matters that are not dealt with in the IBA rules that sometimes need to be explicitly addressed. For example, issues of privilege are very, very much by jurisdiction. And settlement privilege in particular is something which common law lawyers will kind of maybe take for granted sometimes, that an exchange of emails between lawyers which might contain an offer of compromise should not then be put before the tribunal. Sometimes that is not necessarily seen the same way by civil lawyers without any kind of malicious intent, right? And you can find that kind of correspondence then being put before the tribunal based on various kinds of arguments. So I think it's important not just to think about cross-examination preparation issues, but anything else where there may be a misunderstanding that's not expressly covered in the IBA rules. It doesn't hurt to kind of put it in advance.
Excellent answer. Anybody want to add anything to that? Judge?
Marginal addition. Well, there was a situation in the same Elsie case I mentioned before of a witness, well, as a matter of fact, a counsel that of one of the 2 state parties who had been, as a lawyer, the lawyer of one of the parties in domestic proceedings. He was hired as counsel by one state, and then he was required to take the witness off because he was talking about things of which he had direct knowledge. And this was already a very interesting episode. But when he was supposed to be cross-examined, he made a statement saying, I am a member, an eminent member of the Italian bar. I have my privilege. I should not respond to cross-examination. However, considering that I am also a witness before this August court, I have obtained from my client the waiver of my privilege, and so you can cross-examine. So what we can draw from this episode, I think, is that there may be a situation of conflicting loyalties and even conflicting legal obligations that are particularly important of members of the legal profession.
Well, I think you're quite right. And the earlier we get to grips with these types of issues in the proceeding, the less mischief they will cause as we go forward. How about a taker for the second question?
Let me not sure I've got the two questions clear, but I'd like to second a point and drive it home. Robert made reference to the IBA rules. We've talked this morning about this divide, of historic divide between the civil law, the common law, and the IBA rules on the taking of evidence, and now we have a separate set of guidelines for counsel. But those IBA rules on the taking of evidence are really a harmonization of the process to bring together the civil law and the common law tradition, neither fish nor fowl, but really a blending of the process. And I tell my students, and I would tell you, that it doesn't matter if you've never handled an international arbitration. If you read and understand the IBA rules of evidence, you will understand how it is done, and every tribunal will be handling arbitrations substantially in line with the IBA rules of evidence. And as Robert mentioned, very often it's my practice to actually adopt the IBA rules of evidence to guide the tribunal and counsel. And each of your questions are actually addressed in the IBA rules of evidence. I could not emphasize more the importance of the mastery of the IBA rules on the taking of evidence to answer many of the questions that you have pressed with your excellent question.
Speaking as a member of that committee, I have to tell you that every one of those questions, there was somebody's blood on the floor, because that's the only way you really got to the compromise that we have is embodied in the revised rule. It was a great, I think, advance for the profession, because it gave us something to look at that we could all use to have those discussions going forward, and most importantly, that tribunals could use to resolve those discussions. Because until then, it was literally anybody's guess, or who was sitting in the chair of the seat that the institution had appointed as to how some of these issues were going to be resolved. And those types of procedural uncertainties can often be outcome determinative in the way in which a case and its evidence unfolds. So Professor Shepard has it right. That's a great place to look. I think we're about out of time. Please join me in thanking this group of wonderful experts who shared so valuably their experiences, and I hope it was helpful to everybody in the room. And I give it back to Larry for lunch.
There's a restaurant just across the way. You'll see it. We'll come back here at 2 o'clock. I urge you to take the opportunity, if you haven't already done so, I've said this before, I know, to read the Teishoku case, which will be the subject of the cross-examination. These will be 2 cross-examiners. One of them, Steve Hammond, will not be here. The questioning by Tim Nelson of the first in the first cross-examination. So we'll have a break, which is not set out in your program, at 3. Another chance to spend some time out there by the Grand Canal in this lovely weather. And then we'll come back, have a second cross-examination. After that, we'll have drinks and so forth to celebrate the conclusion of this seminar. So now we'll adjourn for lunch.